Greetings to all. Welcome to Future Officers Academy. Today we are going to see the hot topic of the year session 13. Under this, we are going to discuss about Chief Justice of India, and the next is Digital Personal Data Protection Act. Here, this Chief Justice of India comes under GS paper 2, and Digital Personal Data Protection Act comes under GS 2 as well as in GS 3 paper. Now we'll have detailed analysis of these two topics. Our first topic is about Chief Justice of India, that is CJI. Under this, we are going to discuss which article does the CJI has and what are the conventions of CJI, their functions and the eligibility criteria, their appointments, removal, all those things we are going to discuss detailedly under this topic. Here, first, we have to know about that the Indian Constitution makes no mention of the selection process of Chief Justice of India. So, there shall be a Supreme Court of India consisting of Chief Justice of India as what says under the Article 124 Class 1 of the Constitution states. Article 124 Class 2 says that Constitution states that the President appoints each Justice of the Supreme Court. Also, in the absence of constitutional provision, convention is used to determine the CJI. What are the conventions? The departing CJI advises his successor to follow a procedure that is solely determined by seniority. Seniority is determined by a judge length of service on the nation's highest court, not by their age. Now, what are the functions of the government under this? The expectation of the Union Law Minister requesting the current CJI recommendation before forwarding it to the Prime Minister. The central government has no say in the appointment of the CJI. What are the eligibility criteria to become a CJI? To be an Indian citizen, it is the foremost eligibility. Then be a distinguished jurist in the President's estimation. Have served as a judge for High Court or two or more such courts in a session for at least 5 years. Also, he has to be served as advocate of a High Court for two or more such courts in session of at least 10 years. And who are appointed the CJI? Under Article 124 of the Indian Constitution, the President appoints the Chief Justice of India and other Justices of Supreme Court. The President shall confer the Chief Justice, Governor, and the Chief Justice of a relevant High Court according to the Article 217, which governs the appointment of High Court judges. A Chief Justice of the Crown serves until the age of 65 years and judges of the High Courts retire at the age of 62. Here, how the removal has been done under the CJI. So, the removal procedure is as judge of the Supreme Court may only removed from office by an order of the President, which is issued following a speech by each house of the Parliament, which must be supported by a majority of the House total membership as well as a majority of House membership. In this, who are all presented for voting? The President was presented with the address during the same session for possible removal based on one of two grounds, which is demonstrated misconduct and incapacity. Only under these two conducts, CJI can be removed. Now, what procedure is used to recommend and appoint judges? The appointment of judges is carried out through the more than 20-year-old collegium system. Which consists of 5 senior judges of the High Courts and Supreme Courts. The Constitution only refers to the President consultations. It makes no mention of the term collegium. The Intelligence Bureau occasionally conducts background checks on the government using the names that the collegium initially recommended for the appointment. The government may object as well as the collegium typically wins out. The Law Minister will forward the collegium recommendations to the Prime Minister, who will counsel the President on the appointment issues once they have been finalized and received from the CJI. What are the reactions have been held against this collegium system is the collegium system primary flaw is to the lack of transparency. Then the Law Commission of India's 230th report says that, which was the field in 2009, suggested that the nepotism might still be in place. There is a greater likelihood of promotion for a close relative or well-wisher who was our political insider, senior advocate or judge on the High Court. It is not necessary for such person to compete. In fact, less competent individuals have occasionally been admitted. The protection of people's personal information online is known as digital personal data protection. Now we are going to see that topic. So here Digital Data Protection Act says that people are using internet and technology more and more, which means that they are sharing a lot of personal information in online, including private messages and financial informations. In current digital era, safeguarding data against misuse, breaches and unauthorized access has become crucial. So under this we are going to discuss these aspects. The bill of 2023, their highlights, problems and the need of this act have been discussed in this. Now what is the aspect of personal data protection? By gathering, processing, storing and sharing the personal data and governed by data privacy laws and regulations that have been passed in many different countries. These laws give people control over their data and place duties on business that manage personal information. Before collecting and using an individual personal data, organizations are required to obtain the individual informed consent. Consent ought to be freely offered, explicit, knowledgeable, and reversible. It is imperative to put in place sufficient security measures to guard against cyber attacks, illegal access, and data breaches. Individuals whose data is being collected, known as data subjects, have the rights to access their data, have it corrected when it is inaccurate, also have it deleted, and be able to restrict or object to specific processing activities. In case of a data breach that might jeopardize people's rights and liberties, organizations are frequently obligated to alert authorities and affected parties. It is responsibility of the organization to adhere to data protection laws and to show their dedication to data privacy by means of policies, procedures, and records. Numerous nations have set up an agency or data protection authorities tasked with upholding data privacy laws, carrying out audits, and handling complaints. Now, the Digital Protection Personal Data Protection Bill 2023, what that it says, this process of creating data protection law commenced in 2017 with the establishment of an expert committee by Ministry of Electronics and Information Technology. An important step was taken when the Data Protection Bill 2021 was published in December 21. The Ministry of Communication and Information Technology, Ashwin Vaishnav, withdrew it in Parliament on August 3, 2022. The feedback that was provided during the consultation process was kept confidential. The request to make the submissions publicly available was also denied in the right of information case. Now, what are the highlights of this 2023 bill are? The bill will be applicable to the processing of digital personal data in India, whether the data is digitalized after being collected offline or online. If such process is done outside of India in order to offer goods and services in India, it will be also covered. Only with an individual consent for a legitimate purpose, many personal data be processed. Certain legitimate uses such as an individual volunteer data sharing or states processing of data for license, permits, benefits and service may not require consent. Individuals are given certain rights under the bill such as ability to access information, request erasure and correction and file grievances are allowed. Government agencies may be expected by the central government from the bill provisions for specific reasons such as maintaining public order, state security or deterring crime. The Data Protection Board of India will be established by the central government to decide cases involving non-compliance with the bill provisions. Now, what are the problems seen in this 2023 law? Data collection, processing and retention beyond the necessary may result from exemptions of the state right process data on the basis of things like national security. The fundamental right to privacy might be violated by this. Risk of injury resulting from the processing of personal data are regulated by bill. The right of data probability and right to be forgotten are not granted to the data principle by the bill. The bill permits the export or personal data outside of India with the exception of nations that the central authority. The terms of the appointments to the Data Protection Board of India are 2 years, after which they can be renewed. The board's ability to operate independently may be impacted by the short-term scope of reappointment. Now, what is the need of this data protection in India? India has advanced in technology and is now our par with other countries, but it lags behind it having a clear, stringent regulations that addresses all the recent changes in handling the personal data. Indian laws are currently inconsistent. To stay current with international trends and cooperate with other countries, India needs to enact new laws. Though India's current Information Technology Act of 2000 effectively addresses the nation's data protection issues, the laws are not sufficiently enforced, making it relatively a soft law. Now, India requires strictly execution when it comes to data protection. India does not have list laws that penalize spam senders like USA and other European countries to do. There is an urgent need for laws that address recent discovered issues. This makes new data protection laws in India more necessary. Also, technology is outdated even before it is introduced, and this is still the case in India today. So, related to this digital personal data protection, there are some of the important cases, such as the first cases, State of Tamil Nadu versus Shuhas Katti. This case was held in 2004. The next case is Union of India versus Amar Singh. It was held in 2011. Next case is Shreya Singhal versus Union of India, which was held in 2015. Next case is Union of India versus Justice K.S. Puttaswamy case, which was held in 2017. The next is Union of India versus Praveen Arun Pratodial in the year 2021. These are some of the cases related to this Digital Personal Data Protection Act. That's all from our today's topics. To get this PDF download, you can get from our Telegram channel. The link is provided in our description. To get more daily current affairs videos, follow our YouTube channel, also our Telegram channel. Thank you.